Imagine you have spent years building your career, your life, and your future in the United States on an H-1B visa. You followed every rule, you renewed on time, your employer sponsored you, you paid your taxes, you contributed to your field, your company, and your community. And now, a new bill sitting in the United States Congress could freeze every single new H-1B visa for 3 full years and dramatically cut how long you are allowed to stay in the country even if you already have one. This is not a rumor. This is not a fringe proposal from a forgotten corner of the internet. This is a real legislative push with real congressional support that could reshape the entire landscape of high-skilled immigration in America. If you are an H-1B holder, if you work in tech, medicine, engineering, or any specialty field, if your family is here on a dependent visa, or if you are a company that employs foreign-born professionals, this bill could change your life in ways that are not easy to reverse. Stay with me, because every detail of what I am about to tell you matters. Welcome to Global Entry News, your most trusted source for clear, accurate, and up-to-date coverage of U.S. immigration law, visa policy changes, green card developments, and everything that affects immigrants and foreign nationals living and working in the United States. We cover the headlines that matter most to the global community building their lives in America, and we do it with the depth and honesty that you deserve. If you are new to this channel, please subscribe right now. Hit that subscribe button and turn on notifications because immigration news moves fast and you cannot afford to miss a critical update that directly affects your status, your job, or your family. Every week, we break down the complex world of U.S. immigration into clear, actionable information that you can actually use. And today, we are covering one of the most significant and most alarming immigration proposals to emerge in recent years, a new bill in Congress that aims to freeze H-1B visa issuances for 3 full years and reduce the authorized period of stay for current and future H-1B holders. Let me walk you through exactly what this bill says, who is behind it, what it would mean in practice, and what you should be thinking about right now if this affects you. The H-1B visa program has been at the center of American immigration debate for decades. Created under the Immigration Act of 1990, the H-1B visa allows U.S. employers to temporarily hire foreign workers in specialty occupations, fields that typically require at least a bachelor's degree or its equivalent. These include software engineering, data science, medicine, financial analysis, architecture, accounting, and dozens of other professional fields. Every year, the U.S. government makes 65,000 regular H-1B visas available, plus an additional 20,000 for applicants who hold a U.S. master's degree or higher. Given that hundreds of thousands of applications are submitted annually, selection is done through a lottery system, meaning even highly qualified professionals have no guarantee of receiving a visa. The H-1B program has long been both celebrated and criticized. On one side, technology companies, hospitals, universities, and research institutions argue that the H-1B visa is essential to filling critical skill gaps in the American workforce, gaps that, they argue, domestic hiring alone cannot close. On the other side, critics, including labor unions, certain economists, and now a growing number of lawmakers, argue that the program has been misused to undercut American workers by replacing them with cheaper foreign labor, particularly through outsourcing and staffing companies that flood the lottery with duplicate applications to increase their odds. It is against this backdrop that the new bill has emerged. The legislation, which has attracted significant attention from both immigration advocates and restrictionist groups, proposes what would amount to one of the most sweeping changes to the H-1B program since its creation. At its core, the bill contains 2 major provisions that are already sending shockwaves through the immigration community. The first and most dramatic provision is a complete 3-year freeze on new H-1B visa issuances. Under this proposal, the U.S. government would stop issuing new H-1B visas for a period of 3 years. No new lottery, no new approvals for new applicants, no new entries into the H-1B pipeline for any employer, no matter how urgent their hiring need or how qualified the applicant. The stated rationale from the bill's supporters is that a temporary pause would allow the labor market to rebalance, create incentives for American companies to invest more aggressively in domestic workforce training, and give lawmakers time to reform the overall program before reopening it. Critics, however, argue that a 3-year freeze would cause immediate, severe, and in some cases irreversible damage to American industries that rely on global talent. A 3-year freeze would not just slow down hiring, it would functionally shut off access to an entire generation of international professionals at the exact moment the U.S. economy is competing hardest for global talent against countries like Canada, Germany, Australia, and the United Kingdom. The second provision is equally significant and in some ways more immediately impactful for people already in the United States on H-1B status. The bill proposes to reduce the authorized period of stay for H-1B visa holders. Currently, H-1B visas are issued in 3-year increments and can be renewed for another 3 years, giving most H-1B workers a standard initial authorization of up to 6 years. Under the proposed legislation, this period would be shortened, meaning H-1B holders would have less time in the country before they either need to have secured a green card or be required to leave. The precise new duration being discussed varies depending on which version of the bill you examine, but the direction is clear: shorter stays, less time to build a life, and more pressure on people who have already invested years in America. For the hundreds of thousands of Indian and Chinese nationals currently caught in the green card backlog, some of whom have been waiting more than a decade and in some cases 2 decades for permanent residency, a reduction in authorized stay duration is not just an inconvenience, it is an existential threat. These are people who came to the United States legally, worked legally, paid taxes legally, bought homes, raised children, and built lives, all while waiting in a system that was never designed to process the volume of demand it now receives. If the authorized stay is shortened and their green card has not yet been approved, they could be forced to leave a country they have called home for 15 or 20 years. Now let us talk about who is behind this bill and why it is gaining traction in the current political climate. The push to restrict H-1B visas has found support from a coalition of lawmakers who frame the issue around protecting American workers. The argument, stated plainly, is that every H-1B visa issued to a foreign national is a job that should have gone to an American. Proponents of the freeze point to cases, some real, some exaggerated, where American workers were laid off and replaced by H-1B workers brought in through outsourcing companies. They argue that the lottery system, which does not prioritize wages or employer type, allows large staffing firms to game the system at the expense of genuine innovation-driven companies. What makes this particular moment different from previous reform attempts is the broader political environment. Immigration has become one of the most polarizing and politically mobilized issues in the United States. Public sentiment on immigration has shifted in recent years, and lawmakers across the political spectrum, not just from one party, are under pressure to show that they are taking action. A bill targeting H-1B visas offers a way to appeal to working-class voters who feel economically anxious without touching the more visible and emotionally charged issues around undocumented immigration. It is a strategic legislative target, which is precisely why it is being taken more seriously now than similar proposals in previous years. The technology industry has responded with alarm. Major companies, including those in Silicon Valley and beyond, have long relied on the H-1B program as a primary pipeline for engineering and technical talent. Industry associations have warned that a 3-year freeze would cost American companies billions of dollars in delayed projects, lost productivity, and competitive disadvantage against international rivals who face no such restrictions on recruiting global talent. Some executives have warned that a freeze could accelerate a trend already underway, the movement of jobs to Canada, India, and Europe, where companies can hire the same global talent without the visa restrictions that increasingly complicate American hiring. Universities and medical institutions have raised separate but equally urgent concerns. Teaching hospitals rely on H-1B visas for foreign-trained doctors doing residencies and fellowships, particularly in underserved specialties in rural areas. Academic institutions use H-1B visas for researchers and faculty in fields where the domestic pipeline of qualified candidates is insufficient. A freeze does not just affect the private sector. It affects patient care, medical research, and the educational institutions that train the next generation of American professionals. What is often missing from this debate is the human dimension. The nurse who has been in America for 8 years waiting for a green card, the software engineer whose children have grown up here and know no other home, the researcher whose work is funded by American institutions and whose findings benefit American patients. These are not abstractions, they are people. For current H-1B holders, the most urgent practical question is what steps to take right now while the bill is still in the legislative process. Immigration attorneys across the country are advising their clients to take stock of their current visa expiration dates, their priority dates in the green card process, and any upcoming renewals. If your H-1B renewal is approaching, filing it as early as possible under current rules is strongly advisable. If you are in the green card process and have options to accelerate through premium processing where available, through exploring EB-1 or EB-2 national interest waiver pathways if you qualify, this is the time to have that conversation with an immigration attorney. The bill has not passed. It may never pass in its current form, but the direction of legislative intent is clear, and preparing for a tighter immigration environment is simply prudent regardless of what happens with this specific bill. It is also worth understanding that even if this bill does not pass as written, it signals a broader legislative appetite for H-1B reform that is likely to produce some version of change in the coming years. Incremental restrictions, wage floor requirements, lottery priority changes, or employer eligibility limitations are all possibilities that have been discussed in various reform proposals. The question for H-1B holders and their employers is not just about this one bill. It is about reading the trajectory of U.S. immigration policy and planning accordingly. For those outside the United States who are hoping to apply for an H-1B in the near future, the situation is particularly uncertain. A freeze, if enacted, would close off what has been the primary legal pathway into the United States for skilled workers from around the world. Countries like Canada have already seen surges in applications from highly skilled professionals who view the U.S. system as increasingly unpredictable and hostile. If the freeze is implemented, that trend would almost certainly accelerate, and the United States would risk losing a generation of global talent to countries with more welcoming and more stable immigration systems. Here is the bottom line. A new bill in the United States Congress is proposing a 3-year freeze on new H-1B visa issuances and a reduction in the authorized stay duration for current holders. The bill has not passed, but it has real momentum in the current political climate. If enacted, it would represent the most dramatic restriction on high-skilled immigration in American history, affecting hundreds of thousands of current visa holders, millions of applicants, and the industries, universities, and hospitals that depend on global talent. The human stakes are enormous, the economic stakes are enormous, and the political forces driving this proposal are not going away. What you can do right now is stay informed, consult with a qualified immigration attorney about your specific situation, understand your options, and make sure your paperwork and timeline are in the best possible shape. This is not the time to be passive. At Global Entry News, we will continue to track every development on this bill and every other immigration policy change that affects your life. If this video gave you important information, please give it a thumbs up and share it with everyone in your network who holds an H-1B visa or is connected to the immigration process. Drop your questions and your situation in the comments below. We read every single one and we do our best to address the most common concerns in future videos. And if you are not subscribed yet, now is the moment, because this story is going to keep developing and you need to be the first to know when it does. Thank you for watching Global Entry News. Stay informed, stay prepared, and we will see you in the next one.